Vidhigya Sangathan. This is the Empowering Legal Minds Building Future Leaders sessions. And Vidhigya Sangathan is a dynamic legal community committed to bridging the gap between legal education and professional practice. We strive to create opportunities for law students, aspiring advocates, and legal professionals through quality education, practical exposure, and meaningful networking. Our mission is that to promote practical legal learning, develop advocacy, drafting, and research skills, connect students with experienced legal professionals, foster leadership, ethics, and professional excellence. What we offer many things, but मैं कुछ चीजें आपको बताऊंगी. That is skill development workshops, webinars and expert sessions, internship and mentorship programs, legal research and drafting training, networking opportunities, and career guidance for law students and young advocates. Our motive is to fit learning law beyond classrooms. And now I'm welcoming my guest, Miss Advocate Mamta Sharma. This is our esteemed guest. So welcome, ma'am. She is advocate on record in Supreme Court of India. She has nearly 7 years of litigation experience before the Supreme Court of India, Delhi High Court, and various high courts, tribunals, and quasi-judicial authorities. She has many expertise in many areas like constitutional law, criminal law, service law, GST and tax litigation, education law, arbitration, public interest litigation, प्रोफेशनल हाइलाइट्स में आपको इतनी सारी चीज़ें हैं कि मैं बता नहीं सकती, इसलिए मैंने कुछ छोटी छोटी चीज़ें हैं जो आपके लिए स्पेशली लिखी है. लाइक एडवोकेट ऑन रिकॉर्ड सुप्रीम कोर्ट ऑफ इंडिया and successfully represented clients in several reported Supreme Court and High Court judgments. Appeared in landmark litigation, connected class 12th board examination during the COVID-19 pandemics. Regularly appears before the Supreme Court, Delhi High Court, CAT, NGT, NCDRC and other judicial forms. अभी आप सब ने आज वेबिनार जो ज्वाइन किया है और आपको मैम सिखाने वाले हैं, ये आपके लिए बहुत अच्छी बात है. अगर मेरे टाइम में मैम होते और मुझे सिखाते ना, मुझे इतना अच्छा लगता मैं बता नहीं सकती. बट यू आर सच में आप बहुत लकी हो. एंड शी इज मोस्ट ऑफ नोन फॉर स्ट्रेटेजिक लिटिगेशन, एक्सेप्शनल ड्राफ्टिंग, इफेक्टिव कोर्टरूम एडवोकेसी, कॉन्स्टिट्यूशनल एक्सपर्टीज. अगर आप इनसे कुछ आज सीख सकते हो ना तो सीख लेना, अदरवाइज आप सब क्या ही बोलूं, कुछ वर्ड्स ही नहीं है मैम के लिए बोलने के लिए मेरे पास. सो लेट्स वेलकम एडवोकेट ममता शर्मा फॉर टुडेज इंसाइटफुल वेबिनार. हैंड ओवर टू यू मैम.
Okay, thank you so much, Simran. Good morning. Oh, sorry. Good evening, everybody. So today, when we, if you must have seen the agenda of and the topic, that is Supreme Court jurisdiction with practical insights. So I don't want to bore everybody with some theoretical lecture wherein you just don't understand, you can't relate it with practical guidance, that how you will be relating the jurisdiction aspect with practical aspect of filing. So one important aspect that I want everybody is that you remain active through the chat conversation, so that in case if I'm asking something, some query, so that you can tell me that, okay, this is what our basic understanding is at present, and this is what we are expecting now from this session. So now to begin with, when we talk about Supreme Court jurisdiction, so the very important, usually people have the perception in their mind, okay, Supreme Court is the highest court in India, highest appellate body, wherein when you have lost from all the courts, then you are coming to the Supreme Court. So how many of you actually know that apart from the appeals, that Supreme Court here as the last court of the country, what are the other jurisdiction? When I say what are the other jurisdiction means, what are the other type of cases that are being filed before the Supreme Court? That we need to understand. Like when we talk about the trial court, we know that okay, all type of suits are filed there, civil, criminal, that's the court of first instance. The same way high court was also having some appellate jurisdiction, original jurisdiction. The same way, whether Supreme Court is only an appellate body, we have some other jurisdictions also which probably we have not explored as of now. Any idea anybody can simply mention in the chat box so that I can see what exactly they know. Okay, somebody mentioned Writ for fundamental rights. Apart from Writ, any other jurisdictions you are aware about?
Statutory jurisdiction.
Okay, so statutory jurisdiction means statutory appeals. There are a lot of appeals wherein directly you can come to Supreme Court as a civil or criminal appeal.
Direct is
Okay.
arbitration. Section
Okay.
11 of Arbitration Act.
Yeah, that is original jurisdiction, section 11. There are multiple remedies. So if I give you the overview, so Supreme Court primarily has 6 jurisdictions. It would be better that some brief notes if you could make, so that later on when you're reading the constitution, when you're reading the Supreme Court rules, you can relate and it becomes easy for you to understand. Because when we talk about Supreme Court jurisdictions, in this you have to relate constitutional provisions with the Supreme Court rules also. If you are reading the Supreme Court rules in isolation, probably you will not be able to grasp everything. So if you will make notes be with you,
Yeah.
then yes.
6 jurisdictions, MSA, it is one is original jurisdiction, then extraordinary original jurisdiction, then appellate jurisdiction, extraordinary appellate jurisdiction, then you have got that inherent and plenary jurisdiction. Those are the 6 jurisdictions which I believe that. Then
Yeah,
there are,
you're
yeah,
right.
and
You're
then
right, Indu, because I know because you have been preparing for advocate on record exam, so you have actually read. But if I talk about majority of audience, who are still exploring the Supreme Court aspects, so they may be very new. So
okay, sorry.
no, that's completely fine. So let's begin with the appellate jurisdiction, which we always feel that okay, this is the jurisdiction which Supreme Court has, and basically Supreme Court is hearing only appeals. Majority of us know that Supreme Court means specially petition under Article 136. That is true to an extent because that is a major aspect. But when we talk about appellate jurisdiction, we'll begin with Article 132 of the Constitution of India. So I would request you to note down that this is the very first article, Article 132 of the Constitution of India, which talks about constitutional appeals. It includes civil and criminal, wherein interpretation of the Constitution is involved. Only when there is an interpretation of the Constitution is involved, then in case if High Court is providing a certificate under Article 134A, then you can come before the Supreme Court directly in appeal. Then there is another 133, Article 133, which deals with civil appeals, wherein High Court grants certificate under 134A. So under 132 and 133, if you want to come before the Supreme Court, you need to have certificate from the High Court, wherein High Court says that yes, there is interpretation of the Constitution involved, or there is a substantial issue of general importance under 133 involved. So Supreme Court needs to hear. Here, then next we move 134. So when we talk about 134, that is a criminal appellate jurisdiction because usually we know that okay, if there is any sentence passed by High Court or affirmed, then you will come to Supreme Court in SLP. But a lot of people don't know that under Article 134, then it has 3 parts. One says if post trial court awarded death sentence in a particular case, suppose trial court has acquitted, High Court reverses the acquittal into death sentence, then there is a right, direct right to the available to the accused to come to the Supreme Court. Then another way, if High Court is trying transferring the case from trial court and then granting death sentence, then again accused can come directly as a matter of right before the Supreme Court. Another is that in case if High Court grants a certificate. Now, this is the theoretical aspect that we know, okay, civil, criminal, and constitutional appeal, you can come. But as a practice, if you talk about Supreme Court practice, it is very rare that somebody is actually filing the appeal under 132, 133, or 134, because it's very rare when trial court is granting death and acquitting, and then High Court is granting the death penalty. So these are very rare instances. It's you people don't ask for the certificate also. What they prefer is instead of filing the appeal under 133, 134, they straight away file 136. Here you need to write and understand one important point, that when you talk about the constitutional provisions of 132 to 134, you can approach the Supreme Court only against the final order, final judgment. But when you talk about 136, you can even come against the interim order. So I'll give you an example. You filed a criminal appeal against the trial court order before the High Court. And you also filed additional application seeking suspension of sentence during the pendency of appeal. Now High Court dismisses that application. So what is your remedy? Are you remediless? The answer is no. You can challenge that interim application dismissal also by way of special leave petition before the Supreme Court. Supreme Court can hear it. That is the remedy. So as we have already understood, the 132, 33, and 34, the important aspect now I would want to discuss, that is special leave petition 136. And I would say when we talk about Supreme Court, 80 to 85% litigation is SLP only against all the orders, either it is civil or criminal. All the challenges are primarily made through SLP. Now, the very important aspect we need to understand when we talk about a special leave petition, usually people get confused because they are not aware. Usually, when they are challenging any trial court order before the High Court, they will either file revision petition or they will file the quashing petition or appeal. But in Supreme Court, when you talk about special leave petition, first, when you there is not just against the High Court. If and you will read the bare text of Article 136, it says any order from any court, any tribunal, any quasi judicial authority, any order you can straight away challenge before the Supreme Court. This is the inherent jurisdiction. Supreme Court has rather held that this is one of the basic feature, and legislature cannot remove this particular power of Supreme Court by way of amendment. So this power cannot be taken away from the Supreme Court. And this is a kind of supervisory jurisdiction of Supreme Court. It ensures that all the other courts are functioning within the constitutional domain, within their own structure and powers. Now we know that when we talk about special leave petition, you can challenge any order, any court, any decree directly, but whether you can do it. So in that respect, there are several judgments time to time Supreme Court has given the explanation that you need to ensure that you follow all the available remedies before approaching the Supreme Court, until unless there is something so grave and there is complete miscarriage of justice that you just have to approach. Then you can approach. But it doesn't mean that as a matter of routine, you will straight away approach the Supreme Court just to threaten the other party. So that you cannot do. This is something you need to remember always. Another important aspect when we talk about special leave petitions is that you are seeking special leave to appeal. It is not an appeal. when you rather in the some next lecture probably I can take you through the performa of special leave petitions, wherein you're not having any prayers, specific prayers. You will only say grant special leave to appeal against so and so impugned order. Thereafter, in case court exercises its discretionary power to hear your matter, wherein they feel there is something substantial question of no involved, then if they grant leave, then all your prayers which were there before the high court, they gets revived, and then court can hear. Now, when we talk about 136, so understand how vast is the jurisdiction. In case, suppose you've challenged order A in your SLP, but during the course of hearing, the defendant highlights that another interim order that was passed. This is how the High Court is functioning or the tribunal is functioning. Then Supreme Court has the power to set aside any other order also which is not subject matter of the SLP. That is the vast power Supreme Court has under 136. Apart from that, it can mold the relief. Suppose your High Court petition, you filed for A and B relief, but when you are coming before the Supreme Court feels that no, this they cannot grant. But suppose you are asking for the appointment, or you were terminated arbitrarily, you challenged before the CAT, then High Court, and now you are coming before the Supreme Court. Supreme you Because now before the High Court, suppose your prayers were asking for appointment, but in Supreme Court, after analyzing all the facts and circumstances, if the court feels now because of the lapse of time or so and so reason, it is not possible. So Supreme Court can hold the relief which will be best in the interest of both the sides, and it may suppose grant instead of reinstatement or appointment, it may grant you compensation which was not the prayer. So it can mold the relief also. That is the power of Supreme Court under special leave petition. So why I actually emphasize too much on this, because this is the major part, major litigation. I would say it's the bread and butter of the advocates who are practicing before the Supreme Court. Now, we'll move on to the next jurisdiction of Supreme Court, that is the original jurisdiction. So, like we know, the court of first instance, usually people understand that when you talk about court of first instance means it's the trial court. Then certain cases are directly filed in the high court. Like if the matter pecuniary jurisdiction is above 2 crore, then original suits are filed before the high court directly. The same way, whether Supreme Court also has some original jurisdiction. Yes, there are 7 original jurisdictions wherein directly you can approach the Supreme Court. To begin with, the very first original jurisdiction is writ jurisdiction. Article 32. So we all know that okay, we can file the writ petition before the Supreme Court. But and another important question here which arises is, when you talk about writ jurisdiction, High Court also has the writ power, Supreme Court also has the power to issue writs. Then what is the difference? Why would anybody, come to Supreme Court directly? What is the difference? So here, from the practical aspect, you need to understand. When we talk about the High Court jurisdiction, it is wider in scope, because there you can file the writ petition not against just the fundamental rights, but against the legal rights also. Or if there is any order from any statute wherein there is no appeal, the appeal is made through writ only. That is High Court. But in Supreme Court, if you want to, so now another important question arises, whether Supreme Court would entertain the writ petition, or they may impose the cost. Why are you directly coming to the Supreme Court? So in this case, you need to recently also I also filed one writ petition, and In education matters, several writ petitions I have also filed. And if you regularly watch the news updates on live law, you would see that in NEET cases, JE cases, CBSE matters, a lot of writ petitions are filed directly before the Supreme Court. And Supreme Court, in certain cases, they have entertained, certain cases they have not entered. When you are filing a writ petition before the Supreme Court, it can only and only be filed when you are alleging that there is a violation of your fundamental rights. No, you can't approach under writ jurisdiction when only there is a legal right violation. That is the difference you need to understand, which will help you. Thereafter, when we talk about the original jurisdiction, we have for petitions also. So I would say approx 5 to 10% every day. Supreme Court litigation, if I talk about, that includes transfer petitions, and primarily those are matrimonial transfers, wherein wife or husband they are seeking transfer from one state to another. So when we talk about the transfer petition from the litigant perspective, it will help you, because suppose if you are taking care of matrimonial litigation before the trial court or the high court, if the parties are from different states, that time, you, in case if you know that okay, if my client wants to get the transfer from one particular state to another, usually the wife is the application, then the remedy is available before the Supreme Court. You can file the petition. When we talk about the transfer jurisdiction, there are three types of transfers. One is constitutional transfer, that is under Article 139(1). If you will see, it talks about the constitutional transfers when there is any substantial question of law involved, and suppose if the matter is pending before the Supreme Court or before two high courts or more than two high courts, then you can, any party aggrieved or attorney general or court suo motu can transfer the petition before the Supreme Court. So that I'll give you an example. Sometime back, Justice Pardiwala bench transferred the GST in the online gaming platforms matter to Supreme Court, because Supreme Court was taking had entertained that particular writ under 32, and there were the same challenges were pending before the High Court. So Supreme Court transferred all those matters. They heard and decided it. So that also happens. Then the second is civil transfers, which talks about the matrimonial transfers under Section 25 or family related matters, civil matters. That transfer petition is filed under Section 25 of CPC, read with Article 139A, 139(2) of the Constitution. Whenever you are talking about any transfer petition, you need to remember that you always go through the Supreme Court rules, because for each transfer, there are specific procedure guidelines mentioned in Supreme Court rules, that this is how you need to draft the petition. These are the important requisites that you need to follow before at the time of drafting and filing the petition. You will not be able to understand and get hold the Supreme Court cases, how you will file, until unless you read it in conjunction with Supreme Court rules. Then another transfer that is there is criminal transfer under 406 CRPC and 446 BNSS. The criminal cases are also okay. You can seek transfer, but it's very limitedly it is exercised unless there is grave prejudice to the accused or there is some threat, some witness tempering threat is there. Otherwise, Supreme Court usually does not transfer the criminal cases from one state to another. So that is the three transfer jurisdiction, original jurisdictions wherein you are directly approaching before the Supreme Court. Now, one practical aspect you need to remember. So suppose there is a transfer from Punjab to Haryana. suppose wife is residing in Punjab, husband is residing in Haryana, or husband filed the case in Haryana and wife now seeking the transfer from Haryana to Punjab. Where would you file the petition? Can you answer, anybody? Whether, because there are two states, so whether you will file the transfer petition before the Supreme Court, or where, what is the appropriate court? Can anybody answer?
Where the lady is residing, wherever the lady is residing.
No,
If it
I
is a
am
in matrimonial cases, wherever the lady is residing,
no
she
no
can
no.
file.
My question to everybody is: suppose the wife is seeking transfer from Haryana to Punjab, then what is the appropriate court? Where should she file the transfer petition?
In Supreme Court only,
No.
from Haryana to from no, on if it is in the same if it is in the same state, then to High Court can do it. But if it is other different states, then of course Supreme Court can, under Section 25 CPC, they can go. They can file that in Supreme Court.
If
Would,
the matter is in district court, then they will file in the district court because Punjab and Haryana is the same high court.
okay, you are
Yes.
partially correct. I will explain. See, Punjab and Haryana both are different state, but High Court is common.
She
Punjab
will
and
file in
Haryana
High Court.
High Court is having jurisdiction over the two states.
Right, right.
Because it is having jurisdiction over the two states, so you don't need to come to Supreme Court. You can file a transfer petition under
High Court
Section
has-
24 before the High Court
High
itself.
Court only. Yes, yes.
The same way Guwahati High Court is having jurisdiction over 4 states. In that case, if any party is seeking transfer within those 4 states, then you don't need to come to Supreme Court. Because usually we think that, okay, if there are 2 states involved, you just have to go Supreme Court. No. If one particular high court is having jurisdiction over the 2 states or more than 2 states, so within that jurisdiction, high court will have the power to entertain the transfer petition. That you really need to remember, because otherwise you may file the petition in the wrong court. That may affect. Now, another original jurisdiction is arbitration. But when we talk about arbitration under Section 11.5, only international commercial arbitration, if it is involved, in that case, directly you have to file application before the Supreme Court seeking appointment of the arbitrator. That you can, that is another jurisdiction. Then another original jurisdiction itself is when it is related to challenge the election of president or vice president. Usually we know, if a lot of you, if some of you are practicing before the High Court, that in under the Representation of Peoples Act 1951, whenever there is any dispute, any challenge in respect of the elections, then High Court is the having original jurisdiction. So all election petitions are filed before the High Court. District Court does not have the jurisdiction. But when it comes to the election, president and vice president, in that case, Supreme Court is the only forum wherein that challenge can be filed. That challenge is heard only by the 5 judges bench. So that also I will try to deal with that in Supreme Court, how the benches function. Because if you would see the trial court and then High Court, the hierarchy, then there are single judges benches. In High Court we have double bench. But in Supreme Court, as a matter of practice, in routine, there will be 2 judges bench. If you will see, you will have 2 judges who will be listening to your SLP. There are certain type of categories wherein single judge can also hear the matter, like minor matters like transfer petition cases. Single judge can also issue notice, but finally they are decided by division bench only. Then there are categories wherein, suppose if there is a appeal filed against the death penalty, then minimum 3 judges bench will hear. If any matter relates to the interpretation of Constitution of India. Then minimum 5 judges bench will hear. And in Supreme Court, you will see the regular bench, constitutional bench. So when you talk about constitutional bench, it means minimum 5 judges bench. If there is any challenge to the judgment which was delivered by 5 judges, then there will be 7 judges bench. So this is how the benches function in Supreme Court. Okay, so this was the original jurisdiction that we understood. Now, just before I proceed with the next part, I would first want to explain the PIL jurisdiction, that is the extraordinary original jurisdiction. Why we call extraordinary? Because this was invented. So anybody can tell me how the PIL concept was invented, because this is something basic. I'm sure you all must have studied during law also. Anybody, the public interest litigation term came into picture, and thereafter how it has become popular. The input. Okay, I can see after Hussain Ara case, ma'am. Bhagwati. Yes, you have rightly answered. Justice P.N. Bhagwati actually, you know, coined this new concept, wherein any person who is not directly aggrieved, who is not having a direct locus standi, can approach the court on behalf of people who are not able to approach. Nowadays, we all know that this term has become so popular and so widely used, even for political purposes and different purposes. But see, it's not that you can't file a public interest litigation. You can certainly file. Supreme Court rule order 38, then sub rule 12. There's a detailed procedure explained that if you are filing a public interest litigation before the Supreme Court, then certain particular information you have to disclose to show your bona fide of the case. So personally filed a public interest litigation 2 times before the Supreme Court. And when you are filing, because filed it as petitioner in person, but in case if you are filing, you can file it through advocate on record. I've filed in both ways, but as a petitioner in person also, and now as an advocate on record capacity. So whenever you are filing, you have to disclose that why you are filing, whether you approached another forum, whether there is any criminal or civil litigation pending against you, your annual income, your source of income, everything you have to explain. And you have to give a specific undertaking also, that in case if any cost, if your petition is, later on discovered to be a frivolous one, then if court is imposing the cost, then you have to bear the cost, and you are showing your financial capacity that yes, you will be able to bear the cost. That you really need to remember, because it's two sides forward, and it can, if it is going against you, you actually, because it's not just going to affect image, is financially also it may be difficult for you. That aspect you need to remember. Because I think when I was dealing with the different jurisdiction aspect, another important aspect from that was highlighted in the beginning by one of the participant was the statutory appellate jurisdiction that was there in appellate jurisdiction, which you also need to remember that apart from SLP, there are more than 20 statutes. If you will go to the Supreme Court, there is a Supreme Court handbook wherein all the statutes are listed. There are around 22 statutes which provide for a direct appeal. So I am not really sure if anybody can tell me at least 2, 3 statutory appeal examples wherein they know that directly we can come to Supreme Court in
Advocates,
appeal.
Advocates Act, Section 28, I believe so.
38, Section
38.
38. This
And
I think you must
then
remember. you must
That-
remember that.
022 Customs Act and Stay Act.
Yes,
22.
okay, exactly. You must remember that in case if there is any disciplinary proceeding against you, in case if there is any adverse order, and then Bar Council India also in appeal holds against you, then against that, if you are coming before the Supreme Court, then there is a direct order
Section
also
30.
under Supreme Court rules, wherein it
Section
explains
30.
the procedure.
Yes.
Yes, absolutely right. So that appeal you need to then in
Consumer
Consumer
Protection Act.
Commission.
Consumer
Here
Protection Act.
I want to give you a practical insight. When you talk about appeals under Consumer Act, in case suppose the initial case is filed before the District Consumer Commission, then you challenge it before the State Commission. Thereafter, in second appeal, you challenge it before NCDRC. Then, if you are coming before the Supreme Court, whether it will be under the appeal, it will be under the SLP. Anybody?
Only.
Hmm?
Appeal.
No, that will be under special leave petition. So these are very small things, because when you are coming to Supreme Court directly after statutory appeal, that statutory appeal is available only when the matter was filed as before the NCDRC, National Consumer Dispute Resolution Commission. It's the court of first instance. Only thereafter there is a direct appeal. So if there is any matter before the NGT, National Green Tribunal, then there is a direct appeal. If any matter filed by any order challenge against Armed Forces Tribunal, then direct appeal. There are a lot of facts that you can study, but ultimately, if you're practicing in a particular domain, you will understand that okay, there is a statutory appeal, and whenever there is a statutory appeal, you need to remember that you have to file the petition under that statute. In that case, you cannot come in under SLP. Though Supreme Court has the power that they can convert the SLP into appeal, because once court grants the leave to appeal, it automatically converts into civil or criminal appeal only. But you need to remember, as a matter of practice, whenever there is any statutory appeal, you go for that remedy only instead of filing SLP. Okay, so now we have covered the appellate jurisdiction, original jurisdiction. Now, another important jurisdiction of Supreme Court. Anybody can guess? Because everybody know SLP filed, writ petition filed. Okay, understood. What
Advisory.
next?
Advisory.
Yes. Advisory jurisdiction of wherein Supreme Court is giving its advice. When we talk about advisory jurisdiction, Article 143 of the Constitution. Yes, somebody has rightly mentioned Article 143. President can refer any dispute, but here we need to ensure that President cannot refer that political matters as disputes. Time back when there was Ayodhya dispute going on, that there was reference made when Supreme Court had declined. It is of political nature. We will not and give our opinion on that. Here, when we talk about the advisory jurisdiction, first, 5 judges bench only will hear it. Second, when we talk about Article 143.1, Supreme Court may give the opinion, may not give the opinion. It is not binding on Supreme Court. But under Article 143.2, if any reference is made by the President, in that case, it becomes mandatory for Supreme Court to answer to that particular reference. Now, yes, you have this Lokesh call mentioned that the proviso of 131 talks about those categories.
Actually, I am Hindu Cole only. It is my husband. So phone is my husband.
Okay, Indu.
Sorry.
So that is there. Now you understand, okay. So advisory jurisdiction means made by president under 143. Apart from 143, are there other references also wherein president can seek advice from Supreme Court, or central government, the tribunal can seek reference? Any idea? Anybody? Because usually when you are studying in your law also, you primarily read about 143. Apart from 143, do we have any reference? Could not hear you, Satish.
Case of pre-constitutional matters.
I am so sorry, I could not understand it though. Oh, see, when we talk about references, then under Article 317(1) also, if it is related to the removal of UPSC chairperson or its members, then also president can make reference. Section 14 of RTI Act, under that also reference can be made to the Supreme Court. Under income tax, yes, Indu, you have rightly pointed out. So under income tax also, there is a reference that can be made. So there are several type of references that are available. So if you will read the Supreme Court rules also, there are particular orders devoted wherein it is talking about different references that can be made and what is the procedure in that respect. So that you should, if you will go through, you will understand that okay, this is how, if any reference petition is filed before the Supreme Court, these are the important ingredients that you need to fulfill in your drafting, and this is how you need to file it. Okay, Ashwani is a pre-constitutional matter. SC must give opinion. Yes, right. Absolutely right. That in that it becomes mandatory for the Supreme Court to give the opinion. Now, if we'll talk about, okay, so because I just now I have seen, so in case in the original jurisdiction, very important topic that I have not discussed yet, that is original suit. So this is something very important, I would say, in the sense that when we talk about original suits, so you must be knowing how a suit is filed before the trial court. So suppose if there is a injunction suit you are filing before the trial court, you know that specific relief act is involved, the procedure is governed by CPC, you know how it will be filed. Now, Supreme Court, before Supreme Court, as the court of first instance, what type of suit can be filed? So that is explained under 131, because somebody when pointed out 131 exception, that's how I was able to remember that I actually forgot to cover 131. Where there is a dispute between the government state, or government and one state, or any state and on the other side other state, or between the two states, then a court does not have the jurisdiction. That suit can be filed only before the Supreme Court. Now, Satish, you have pointed out that these are federal disputes. Now there is a change also. So it's not just the federal dispute, but in case if there is a legal dispute. So there was a matter recently in 2024. There was state of West Bengal versus Union of India, wherein they challenged that they had withdrawn the consent under that the DPSP Act and Section 6, and in spite of that withdrawal of consent, they CBI continued to investigate the matter. So that was curtailing the power of the state. So Union of India had challenged the maintainability. They said no, this type of matters you cannot deal under 131. So Supreme Court had said no, these type of disputes are also maintainable and can be heard. And there are several instances now wherein Supreme Court is entertaining the legal disputes also between the states, wherein state is challenging, like state of Kerala had also challenged amendment to the Citizenship Act before the Supreme Court in the suit jurisdiction, because they said that you are curtailing your, it is affecting the rights. So court said okay, it is maintainable. So the scope is expanding. So it is important that you updating yourself, your through the judgments, the latest happenings, because we all know law is dynamic. So there, if there is a particular interpretation, anything mentioned in the constitution, then how that is being interpreted by the Supreme Court over the passage of time, that you will understand when you are going through the judgments. So that aspect is important. Now, moving on to the next jurisdiction after advisory is inherent and plenary jurisdiction. Any idea? Anybody can tell me what is the inherent and what will come under this jurisdiction? Apart from Indu, I would say, because I know she is preparing and she is practicing the Supreme Court also. So anybody who has any idea about the inherent or plenary jurisdiction of Supreme Court? Started during law.
Article 142.
Article
Article 142 to do complete justice.
one. Yes, Article 142 to do complete justice and
Curative petition. That is also 142 council.
before I go, I would relate two aspects. Article 129,
Court of contempt canon.
court of record, which is having the power to punish for the contempt, and read with 142, and then contempt of court act under section 19. There is an appeal which can be filed before the Supreme Court, and Supreme Court is having its own rules. So in case if you are directly filing any contempt petition before the Supreme Court, then how it is filed and what is the procedure, there are specific rules framed by the Supreme Court that are to be followed in the contempt jurisdiction. So that contempt jurisdiction of Supreme Court falls under this category. So you all say that, okay, 142, how it is used now. This is important. Any example can you give wherein Supreme Court has exercised powers under 142?
Rupa Ashoka Hora case.
Rupa Ashok case. You said, right?
Yes.
Okay, any case, any example, other example? Rupa Ashok case I will actually deal under when I'll explain the curative also. Apart from that, see, when we talk about 142, this power available to the Supreme Court to do complete justice. But when some procedural aspect is coming in between to do the complete justice, but while exercising the power under 142, you cannot override the statutory provision. That you can't do. So suppose we talk about the Shilpa Shale's case, wherein court evolved a new case. Yes, absolutely right. Bhopal gas tragedy case, the court had exercised 142 powers to do complete justice in terms of granting compensation. Then Shilpa Shale's case, if you court came up with a new concept of irretrievable breakdown of marriage, and court granted. Parties were not willing, but court granted the divorce, exercising that otherwise it will be grave injustice. So their court exercise. Now I will talk about the practical aspect. General, frequently Supreme Court is using 142. So I explained you earlier. Okay, Rajiv Gandhi assassination case, also another example is given. In general, in daily routine, I told you that lot of transfer petitions are filed before Supreme Court. So here you need to understand as a practitioner that when you are talking about the transfer, when you are seeking, it is actually used as a tool also. So I'll give you my example how I use at times when I'm representing, suppose, the husband, because usually when you are as a wife seeking transfer, and if the trial has not commenced and you are showing a genuine hardship, court will transfer when it is filed by a wife. But if husband is filing a transfer, usually they don't get transferred, they will be dismissed. So as a husband, suppose if I'm representing the husband, then what I will do? I know That petition, if I am filing, court will not transfer it. It will be dismissed. Then why I am filing it? In that case, suppose when you know that in case if you are filing it before the Supreme Court and then you are requesting that, my lords, instead of transferring to your lordship, may first at the instant transfer it to mediation. There is a possibility of amicable settlement. So for that limited purpose, court will transfer it to mediation. And I believe me, it is very effective because when parties are appearing before Supreme Court mediation, their mindset is also different. And how if the senior mediators handle, because I think Induji is a mediator also before Supreme Court, so she also must be having that experience.
Yes.
When parties come before the Supreme Court, their mindset is also different. The more is likelihood of settlement. So in that case, if you are supposed representing the husband also, you know that it will not be transferred, but you are filing it so that you can explore one chance of settlement before the Supreme Court mediation. Suppose if it gets sorted, if you are able to settle, now if there are 5 cases between the wife and husband, what will happen? You don't have to make a settlement in a case that, okay, husband and wife will withdraw their cases respectively. What you will do in the mediation settlement, you will mention that all the petitions will be subsequently in application under 142 will be filed by the parties seeking a quashing of these and the cases. So you don't have to go to any other court. In that case, in that transfer petition itself, if you are filing 142 application, court will then and there quash all the petitions, all the cases. So that actually saves the hurdle, time, money, harassment, everything. This is something very important because we know how the matrimonial litigation is increasing. So in that case, if you know how to tactfully utilize this transfer jurisdiction, you can actually save years of litigation, unnecessary harassment. You don't have to go to high court for seeking quashing and wait for further time. So effective remedy you can get before the Supreme Court. So that is how effectively you can use that transfer petition, and then in transfer petition 142 powers you can invoke of the Supreme Court and you can get the relief. So that you can do. Another question now I would want to ask when we talk about this plenary and inherent jurisdiction. Usually now we think, okay, Supreme Court, suppose SLP dismissed, allowed. Any aggrieved party now, everything over. So according to you, do you think there is anything left thereafter? Once SLP or civil appeal, criminal appeal is decided, thereafter, before the Supreme Court itself, whether there is any other remedy available?
Curative petition.
Okay, so is it so one after the SLP, whether this is the next step?
No, no. Review. First review, then curative.
Yes. Before curative is the last. Before that, there is review. Just check
Article 137.
137.
Right.
When you check Article 137, it gives the power to review. Now, one important aspect you need to remember, the difference I would say, normal context, when we talk about the review jurisdiction, whether it is high court or trial court, review jurisdiction we all know, okay, if it is a civil matter, okay, review lies. If it is a criminal matter, 362 CRPC, court becomes functus officio, no review lies. You only have to go in appeal. But whether in Supreme Court can hear review against criminal matters, yes or no? Anybody has any answer? Can Supreme Court hear review in criminal matters? Whether Supreme Court has that power? Any guess? From the fair reading of Article 37? Okay, we'll answer.
Yes. Actually, review we can file for criminal also, because a review in this case is whether there is an apparent, any miscarriage of justice or something. So we can file review in both the cases.
Yes, this
It is
power.
added on apparent on the record, right?
So
That is
this
what
power
review.
review of criminal judgment also lies only with the Supreme Court. High
Only
Court does not have this power.
yes, yes.
Any other court or tribune does not have that power. Only Supreme Court can review any order, any judgment. The limitation is of 30 days.
Now,
But
actually, in Domestic Violence Act, there is a appeal inbuilt in Domestic Violence Act, which has come in 2006. So,
mhm,
in that case, appeal lies to the session, this
yes, under
magistrate,
I think under
Nice
22.
29. Yes. Then
Mm,
revision comes in the High Court in Domestic Violence Act. Otherwise, revision is not
yes.
presentable in High Court.
But the same court once passes a judgment in a criminal matter, unless there is some clerical matter, the same court, same judge can't hear it. But only yes, on the face of record, this is one of the primary criteria. If you will read Order 47, Supreme Court rules also, it has explained that in what case you can file for review before the Supreme Court. The limitation is of 30 days. And then in civil cases, Order 47, Rule 1 of CPC, the grounds which are mentioned there, the same grounds, the basis of the grounds you can file. But there is another important clarification when I would say there are a lot of judgments with the passage of time where the Supreme Court has extended the scope, wherein in the interest of justice, in case if there is any other important ground, court can consider. But the only difference here is that when you talk about review as a matter of right, you don't get any hearing. That review petition will be circulated before the Supreme Court bench, which heard the matter, the same bench in their chamber. Then, in case if they feel that yes, a hearing requires, then they may keep it again for open hearing, or they may give you relief in chamber itself. So that can happen, but as a matter of right, you don't get the right to hear, right of hearing in review petition. Now, suppose you file a review petition against the death penalty cases. Only in this, there is a difference that in case if a review petition is filed against a death penalty, when Supreme Court has also affirmed, then it as a matter of right, they will get the open court hearing even in the review petition. That is the only exception in review. Now, suppose review also you don't get the relief. What next? So, as somebody had pointed out, curative petition. This is the last resort. So, in case if you have failed till review, you can file a curative petition, and the detailed procedure is mentioned under Order 48 of Supreme Court rules, wherein it has explained that this particular concept was evolved in that Rupa Ashok Hura 2002 judgment, wherein writ petition was filed challenging the Supreme Court order itself. So, in that order, Supreme Court said that you cannot challenge our order by way of filing a writ petition. That is not permissible. So what you can do, but we need to evolve with a particular mechanism wherein if there is a travesty of justice and it is important and gross abuse of process, then we can have a curative. But the threshold is very difficult because if suppose you want to file a curative petition, you need to have a designated senior advocate certificate that yes, in terms of Rupa Ashok Hura judgment, this is meeting the criteria, the petition is maintainable. So that way you can file. And when you file the curative petition, because in normal course, as I had explained to you, that in Supreme Court, usually the matters are listed before division bench. But when you are talking about the curative petition, it gets listed before 5 judges bench in chamber. So there is no open court hearing in curative also. that curative petition also gets circulated in the chamber. So, in case if they feel that yes, it is to be heard, then the same judges, 5 judges bench who issues the notice and curative petition, that will hear that matter and will proceed whether it requires intervention or not. That is there. Now, do you think that in case if any SLP is dismissed, writ petition still lies? Because after this Rupa Ashok Hura, Supreme Court conclusively settled the controversy that in case if you want to challenge, then the only process is review and curative. Still, any exception? Anybody? Any idea? Any case came before the Supreme Court? Okay, only in the death penalty cases, wherein Supreme Court has also affirmed the death sentence, then only in that case, if accused challenges that at the time of sentence he was not given a proper hearing, then he can file a writ petition before the High Court or Supreme Court. Otherwise, there is no other option. Otherwise, writ is not maintainable. You have to go with review and curative. That is there. I think most of the jurisdiction I have covered. In now, I would instead of explaining, I would rather would like to take up the questions, practical queries that you have in your mind, so that you can relate and understand. Because it's all something you can't keep in your brain in 1 hour session. You have to relate it with the constitutional provision and Supreme Court rules. Then you will understand that okay, this is how the practice works in Supreme Court. I would welcome questions now from your end. Anybody is having any question, any query? So don't think any query can be a layman query. Anything, any doubt you have in respect of Supreme Court practice, feel free to ask.
If anyone want to ask any questions, you can. And ma'am, I want to share something before I deliver the vote of thanks. I like to share something with you. As
Okay.
discussed with you earlier, Vidhigya Sangathan is committed to organizing webinars that bridge the gap between legal education and tactical learning. Continuing this initiative, we are delighted to announce our upcoming webinar on exploring trademark and GI in India, legal framework and tactical aspects, and this is aspects by Miss Mansi Soni, scheduled for 28th June at 8 p.m. We warmly invite you, and हमें बहुत खुशी होगी कि अगर आप आएंगी मैम, and ma'am, and all our participants to join us for another enriching sessions. आप सब भी जिन्होंने आज ज्वाइन किया है, अगर आप ज्वाइन करेंगे तो आपके लिए और भी ज़्यादा वैल्यूएबल रहेगा ये. Now, on behalf of Vidhigya Sangathan, I extended my heartfelt gratitude to Advocate Mamta Sharma for sharing her invaluable knowledge and tactical insights with us today. Thank you, ma'am, for your time and guidance.
Sorry
I
for interrupting.
also thank all our participants for being with us.
एक बार
Thank you,
questions
everyone.
हो
Have a
जाने
great
दीजिए.
evening. And now I hand over mic to Dev sir. Please speak.
एक बार क्वेश्चन जो हैं उनके वो क्वेश्चंस एक बार हो जाएं, उसके बाद मेरे लगता है वोट ऑफ थैंक्स ठीक रहेगा.
ओके सर, अब जैसा कहोगे मैं दोबारा बोल दूँ. मेरे को मैम को थैंक यू बोलने में बहुत अच्छा फील हो रहा है बिकॉज मैम ने इतना अच्छे अच्छे इंसाइट्स दिए
तो वही
हैं. मुझे भी नहीं
मेरी क्वेरी है मैम
हाँ पूछिए.
कि क्यूरेटिव पिटीशन के बाद भी कोई ऐसा प्रोविजन है जिसमें हम जा सकते हैं?
मर्सी पेटिशन सर.
No, mercy petition
प्रेसिडेंट
is
के पास जाओगे ना, और कहाँ जाओगे?
नहीं, mercy petition you're talking about criminal matters.
Yeah, criminal matters can
But
go.
there,
It's
see,
a service matter.
हाँ.
after
As we
curative,
discussed before
There is
about
no
my,
other. There is no
regarding
other.
my friend.
once the curative petition was something extra constitutional mechanism which was evolved by the court. So there is no constitutional provision which talks about it. Part, curative, nothing remains.
Yes, yes.
That is the last.
Yes, criminal में तो you can go for this mercy petition and बाकी civil वगैरह में नहीं है. Then one more thing, ma'am, जो 131 में जो provision है हमारा, where there is the treaty and other things, that were also उसमें दो फर्क है 143 and
रिक्वेस्ट टू इंदू मैम प्लीज ऑन योर कैमरा. और मैं स्पेशली थैंक्स आपको बोलूंगा, ये आपने पूरा सेशन बिल्कुल लाइव रखा.
हाँ नहीं मुझे अच्छा लगा नहीं मेरे को तो अच्छा लगता I just join everywhere like where there is a legal knowledge coming. I appreciate ma'am Mamta what she has started and I really this is very good insight for Supreme Court because कई लोगों को पता हम लोग तो प्रैक्टिस करते हैं हमको थोड़ा बहुत पता है इतना नहीं पता बट कई लोगों को नहीं सुप्रीम कोर्ट जाते रहते टाइम लगता है एंड आवर एज एंड ऑल दीस थिंग्स वो तो कोई बात नहीं लेकिन मेरे को ये
पार्टिसिपेंट्स हैं
ममता जी
सारे सारे हाई कोर्ट और डिस्ट्रिक्ट सेशन कोर्ट के एडवोकेट्स हैं और तो एक आपकी वजह से ये लाइव सेशन रहा. अदरवाइज क्या है कि वन वे कम्युनिकेशन होता.
नहीं 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 ऐसे ममता जी आई एम रियली मतलब मैंने पूरा सेशन खाना भी खा रही थी आपका सेशन पूरा सारे लोग बोल रहे थे डिस्टर्ब कर रही हो मैंने कहा नहीं सुन लो सारा बिकॉज माय बोथ सन्स आर इन प्रोफेशन. तो यू हैव स्टार्टेड अ वेरी गुड सेशन बिकॉज क्या है जो आपने मोटा मोटा बता दिया ना these are very like unique things which are usually practicing.
एक हम लोग आगे भी ये सेशन रखने वाले हैं कंटिन्यू सेशन चलने वाले हैं और मुझे लगता है कि आप दोनों का ये सहयोग रहा तो हम लोग यहाँ ग्वालियर में बैठ के एक्सपर्ट हो सकते हैं.
I will be very मैं कहती हूँ फॉर्चुनेट है कि जहाँ पे हम शेयर क्योंकि शेयर करने से क्या होता है अपना भी थोड़ा पढ़ने में वो हो जाता है एवरी टाइम तो वी डोंट सिट एंड रिमेम्बर रिकॉल द जजमेंट्स तो अदरवाइज तो हाँ तो एक दूसरे को बात करके जिसको मालूम है जिसको नॉलेज है तो वो अगर शेयर करते रहे आपस में इट विल गिव गो
इसमें दिव्या जी व्हाट आई विल डू आई विल सेंड यू violation of certain judgments on important jurisdictional aspects wherein Supreme Court has given interpretation so that
मैं आपको बताऊं जो हमारी ये 86 जजमेंट्स है ना जो एआर के जजमेंट्स है दैट कवर्स एवरीथिंग दैट इज ऑल उन्होंने हमारे को 7-8 जजमेंट्स तो हमारी क्रिमिनल की हैं कुछ हमारा पीआईएल की हैं 10-12 जजमेंट्स कुछ हमारे रिजर्वेशन की जजमेंट तो उसमें आपका सारे आर्टिकल्स आ जाते हैं. सो इट इज बेटर कि वहां से हम क्योंकि अगर हमारे में से कोई और भी यंग लोग जो बैठे हुए हैं अगर कोई भी करना चाहे और के एग्जाम प्रिपरेशन करना चाहे कुछ करना चाहे तो उनको एक इंसाइट मिल जाएगा कि व्हाट एग्जैक्टली सुप्रीम कोर्ट डू क्योंकि वो जजमेंट सी इटसेल्फ फॉर इज टोटल कॉन्स्टिट्यूशन तो वो अगर जजेस के लिए कोई तैयारी कर रहा है तो वो जजमेंट्स उनको काम आ जाएंगे. सो आई बिलीव अगर हम वो जजमेंट्स यहाँ पे रिवाइज करें तो बहुत अच्छा है क्योंकि मुझे पता नहीं था कि आपने आज शुरू करा बिकॉज फॉर 1 month I was away. I was in Srinagar.
Okay.
So yes, day before yesterday I came back. तो मेरे दिमाग से सारा वाइप आउट हो गया था बट जब आपने रिकॉल कराया तो मेरे को एक चीज याद आ रही
नहीं ये होता है उसके
क्योंकि एग्जाम पोस्टपोन हो गया ना मूड बड़ा खराब हो गया एग्जाम पोस्टपोन हो गया इट वाज लाइक नॉट अ गुड स्टेप व्हाट सुप्रीम कोर्ट हैज डन बट आई डोंट नो मैम आई डोंट नो मे बी गुड लक फॉर समबडी.
जब नॉर्मल बातें करते हैं whatever provisions we have till unless the practical that okay this is how Supreme Court has expanded the scope like, there are a lot of cases I can't cover everything that when you don't need to file review you can file a miscellaneous application before the Supreme Court then you can get the relief.
नहीं फिर हम अगर बात करेंगे मैम आपको थोड़ा सा जैसे हम जैसे नीचे वाली कोर्ट में डिस्ट्रिक्ट कोर्ट में हाई कोर्ट में कोई इंटरलॉक्टरी एप्लीकेशन लगा देते हैं कोई हम आईए फाइल करते हैं सो हाउ टू फाइल इन सुप्रीम कोर्ट सो दिस विल गिव लॉट ऑफ नॉलेज टू ऑल ऑफ अस तो अगर इसमें भी थोड़ा सा आप करेंगे तो अच्छा लगेगा.
Exactly, that is actually the agenda because earlier we were thinking that we will cover jurisdiction plus drafting but then it would extend to more than 2 hours because when you're talking about drafting
का तो फिर एक क्लास ही अलग रखेंगे ना मतलब it is
to be a separate class which will talk about what are the different type of filings how you do it and then what are the IAs
are you doing it daily basis पे करेंगे weekly basis पे कितना मतलब
no that we will decide because I am only speak because this is the platform is being
because Pooja Singh had given me your link and मैंने एकदम ज्वाइन कर लिया फिर मेरी आदत है जहाँ पे भी मेरे को ऐसे लिंक आती मैं ज्वाइन कर लेती फिर बोल देती हूँ कुछ ना कुछ बीच में. I'm sorry to
No, no.
इस तरीके से डिसाइड करने वाले हैं जिसमें वेकेशन रहे और किसी का कार्य प्रभावित ना हो, जो हमारा रेगुलर कोर्ट वर्किंग है वो।
शाम का टाइम कर दीजिए, जब मतलब संडे वीक में 2 बार
सैटरडे
भी
या
क्लास
संडे
हो।
इवनिंग में, या फिर किसी दिन वीक में कोई बीच में ऑफ होता है। आज सपोज आज एक ऑफ था, उसका हमने फायदा उठा लिया।
हाँ।
बाकी
अब
एक
छुट्टियां भी खत्म
important
हो जाएंगी ना सुप्रीम कोर्ट में, तो
ये
फिर छुट्टी।
जो भी सुप्रीम कोर्ट में आई वुड से वांट्स टू अंडरस्टैंड प्रैक्टिस, whenever you get time and you don't have matter, you should try to come to Supreme Court, you should visit it.
Yes.
Because suppose if you're aspiring to practice in a particular court and you're just not coming there, how would it happen? So when you are coming to the court, experiencing the live atmosphere and how people are
क्योंकि
working,
मैं
arguing, then it will be a different feel altogether.
I would advise everybody whosoever is not like has a मतलब नॉर्मली क्या होता था, मेरे भी आधा उम्र हो गया तो आई नेवर सुप्रीम कोर्ट में इतना काम होता था कि सुप्रीम कोर्ट जाने का, बट नाउ आई कैन अंडरस्टैंड, लाइक मैं सबको ये गाइड करूंगी, ये सबको एडवाइस करूंगी राधा, कि जो भी कहीं पे जॉब कर मतलब प्रैक्टिस करता है वो सुप्रीम कोर्ट की कॉन्स्टिट्यूशनल बेंच में बैठे या किसी भी बेंच में कहीं पे भी बैठे, रेगुलर बेंच कहीं पे भी, उससे काफी कुछ नॉलेज होता है एंड इट विल हेल्प यू इन योर डेली प्रैक्टिस in any
Yes,
court, in any court.
actually, I'll give you Divyaji one instance. Won't take more than 2 minutes. I would give you an example. What happens in district court? Because I usually now I'm not taking up the matter. I only go for the arguments. But there is a mindset that no, this is how the court functions. They would not use their brain that okay, if there is a particular provision, there is a particular mandate, then how court can decide like this? They are so fearful of judge.
दूसरा
is
एक चीज और
important.
कहना चाहूंगा मैम कि क्या था कि लास्ट ईयर एक बच्ची आई मेरे पास एमईटी कॉलेज से इंटर्नशिप के लिए, तो उसके दिमाग में एक फोबिया था कि वकील थोड़े अकड़ू टाइप के होते हैं। जब मेरे साथ उसने इंटर्नशिप की तो उसके बाद कहा सर एक बात कहनी है मेरे को आपसे, कि मेरे दिमाग में एक इस तरीके से बना दिया था इमेज कि वकील गुस्से वाले और अकड़ू और मिसबिहेव कर सकते हैं कभी भी, यदि आपने कुछ पूछा जवाब नहीं देंगे और वो, लेकिन आपके साथ लगा ही नहीं कभी कि इस तरीके से भी हम सीख सकते हैं। वही मैं कहना चाहता हूँ कि सुप्रीम कोर्ट का एक फोबिया था हमारे दिमाग में, हो सकता है अन्य जो लोग हैं उनके में भी, लेकिन वो फोबिया आज मेरे को लगता है हमारे दिमाग से निकल गया है। और ग्वालियर से दिल्ली कोई बहुत दूर नहीं है हमारे यहाँ से,
बहुत दूर।
वहाँ से आप बड़े आराम से आ सकते हैं।
जब तक आप किसी कोर्ट में नहीं जाते हो तब तक ही वो डर है। Once you
जी, जी।
enter in the court, that fear completely goes. Then you feel, oh, it's like a normal court. Rather, you learn a lot. Because here, if there is anything wrong, people will challenge it. That if there is a constitutional provision, it's not followed. Suppose if you will have knowledge of court and high court, then if you are practicing before the trial court, your level of confidence will be a different level altogether, because you know, okay, judge is going in a wrong direction, you'll challenge it immediately, you'll go in appeal. It is important that you are aware how you will proceed in the ladder.
किसी की कोई क्वेरी है क्या? If any person have any query, then they may ask to the ma'am. Otherwise, we will conclude our session.
Thank you, Mamta ji. Thank you, Mamta ji. Carry on. You carry on. I'm with you. I love this session. I have a good, appreciate your these efforts. और आएंगे बच्चे इसमें काफी सारे आएंगे, because once you have started,
बच्चे भी आएंगे और मुझे लगता है एडवोकेट्स भी आने वाले हैं। I'm fully confident about it.
हाँ, सबको लाएंगे, कोई बात नहीं।
जी अनोखी।
Is there any question? We know.
हाँ, अनोखी राज कोई है पार्टिसिपेंट है, उनका एक रेज किया है।
Yes, अनोखी, please unmute.
हेलो मैम।
ऑन योर कैमरा अनोखी प्लीज।
मैम वो मेरे को मतलब ये कहना था कि अगर आप, मेरा फर्स्ट ईयर है तो थोड़ा सा अगर आप हिंदी में भी मुझे समझाती तो बेहतर होता, क्योंकि अभी फिलहाल थोड़ा इंग्लिश बाउंस कर रहा है, तो बीच में अगर आप थोड़ा सा हेल्प करती हिंदी में तो ज्यादा बेहतर से समझ आता।
आगे अगले सेशन में रखेंगे कुछ इस तरीके से।
ओके, थैंक यू सर, थैंक यू मैम।
Try, because you actually what happens, जो बाकी स्टेट से, जैसे अगर नॉर्थ को हटा दो, इन केस इफ यू साउथ में जाए, उनको हिंदी बिल्कुल नहीं आती।
एक
तो
बार
आई
ऐसा
नो
हुआ था।
मैम, बट स्टार्टिंग है ना तो थोड़ी सी प्रॉब्लम्स आ रही है, तो मतलब थोड़ी सी, बट आई
चलो
ट्राई
सर,
टू अंडरस्टैंड।
आगे से हम
थैंक
लोग
यू
ध्यान
मैम,
रखेंगे इस बात का, है ना।
थैंक यू सर।
दूसरा, एक बार ऐसा हुआ था मैम, मेरे साथ में हुआ था कि एक दो स्टूडेंट केरल और कर्नाटक से थे। मैं हिंदी में बता रहा था, लेकिन जब उनकी क्वेरी आई कि सर प्लीज स्पीक इन इंग्लिश, तो मुझे दोनों में इस पे अलग से बोलना पड़ा। जो सेशन 45 मिनट्स का था, वो 1.5 आवर हो गया था।
नहीं, एक मिनट है ना, जो आप सुप्रीम कोर्ट में जो लैंग्वेज है दैट इज इंग्लिश ओनली। सो मैं मैडम से, जो मैडम ने अभी क्वेरी करी, हिंदी में भी समझा दीजिए, वो तो ठीक है, बिकॉज शी इज इन फर्स्ट ईयर, तो हिंदी में समझाना कोई बुरी बात नहीं है, वी कैन मेक देम अंडरस्टैंड इन हिंदी ऑल्सो। बट प्रॉब्लम ये है कि जो आप जब सुप्रीम कोर्ट की प्रैक्टिस करोगे बेटा, तो आपको वहाँ पे सिर्फ इंग्लिश में ही बोलना पड़ेगा, हिंदी में सुनते नहीं, नंबर वन। नंबर टू, अगर आप जो आप मैडम ने पढ़ाया, आपको जैसे आर्टिकल्स पढ़ा दिया, अगर आप एक बार पढ़ोगे उनको और नेक्स्ट सेशन में जब मैडम समझाएंगे आपको, तो आपको बिल्कुल समझ में आ जाएगा, यू विल अंडरस्टैंड।
मैंने भी सभी
या
स्क्रीन
थैंक यू मैम।
यस यस।
एक बार जो भी हमारा टॉपिक है उससे रिलेटेड पढ़ के आना,
हम्म।
और पेन और डायरी
ओके
साथ में रखना।
सर, डन सर, थैंक यू।
आपने आपने सर मतलब देखिए, आज आपने मेरे ख्याल में 80% ऑफ द प्रैक्टिस विच इज इन कोर्ट, तो वो आपने समझा ही लिया। अब अगर सारे हम लोग इसको एक बार फिर से कॉन्स्टिट्यूशन खोल के देखें, जैसे मैडम ने बताया आपके 6 टाइप के जुरिडिक्शंस हैं, तो वो नोट किया होगा आपने, तो आप वो आर्टिकल भी नोट कर लीजिए, तो वो आर्टिकल एक बार पढ़ लो, तो यू कैन अंडरस्टैंड, नेक्स्ट टाइम आपको बिल्कुल मुश्किल नहीं लगेगा।
बिल्कुल।
थैंक यू मैम, थैंक
Okay,
यू सो
so
मच।
as we have
Shall I leave now?
no, ma'am, no, you cannot leave. I have something.
ठीक है।
As we come to the end of today's session, I would like to express my heartfelt gratitude to our esteemed speaker, Advocate Mamta Sharma, for sharing her valuable knowledge and practical insights and real life experiences with us. Ma'am, thank you for your time and for
Thanks.
making these sessions so informative and inspiring.
Thank
A
you.
special thanks to Mrs. Lokesh Kaul, whose engaging,
हिंदू में
practical,
है ना।
and thoughtful questions
Thank
made today's webinar lively, interactive, and even more enriching for everyone.
Thank you. Thank you so much. God bless you all.
Thank you, ma'am. I also extend my sincere thanks to all our participants for joining us and to the entire Vidhigya Sangathan team for their dedicated efforts.
आपने आपने ये नाम बहुत अच्छा चुना है, इसीलिए I got attracted. What is it? मतलब how could you just get this name?
My name.
Title.
एक दिन मैं मेरा ही सोचना
Vidhigya
था
Sangathan.
Hmm.
Yes.
कि विधिज्ञ यानी कि लॉ से रिलेटेड सारे लोग एक साथ काम कर सकते हैं क्या, तब ये नाम निकल के आया था।
Very good. बड़ा good
ये
thought.
आपका जो है संगठन काफी अच्छा इनिशिएटिव है। तो लिंक्डइन पे एवरी नाउ एंड देन आई गेट लॉट रिक्वेस्ट फॉर इंटर्नशिप, associate opportunity. So in case if your platform is providing that kind of assistance, then I think there can't be anything better than that, because that is actually
we are trying to do it, ma'am.
All the best to
Yeah.
you. All the best to you, and you
the very
just grow.
best, and it was
grow.
actually really
Just-
enjoyed explaining the
मजा
different
मजा आ गया,
jurisdictions.
मजा आ गया, आपने रिवीजन करवा दिया कॉन्स्टिट्यूशन का। थैंक यू। मैं भूल गई थी, एक महीना बिल्कुल टच में नहीं हूँ, एक महीना पूरा जून के। I was in Kashmir for all the valley through. तो कल रात को ही आई हूँ, I'm so tired, मैं आज गई नहीं, मेरे को काम था, but I got this your link, तो मेरे को नाम ये बड़ा अट्रैक्टिव लगा, तो मैंने कहा चलो इसको ज्वाइन करती हूँ। दिन में ऐसा ममता जी हैं, मैंने कहा था गुड। ममता यू
Okay, I
डूइंग द
think
बेस्ट।
thank
बहुत
you
बहुत
so
अच्छा,
much.
बहुत अच्छा, बहुत अच्छा।
And I think we have. I don't think there is any further query. So can I take
I
your
think we
leave
should
now?
conclude it.
Please,
Yes.
thank
Thank you.
you. Simran ji, can I leave now?
Yes, ma'am, you can
Yes,
leave,
ma'am,
and thank
sure.
you so